Let's talk money.
Hello and welcome to a brand new edition of Let's Talk Money. I'm your host, Surabhi Upadhyay. As savers and investors, we spend most of our lives trying to create wealth. But perhaps knowing the rules that govern the transfer of this wealth within the family or maybe even outside the family is perhaps as important. And that is what we are aiming to do on the show this week. The idea is to understand the laws that govern succession and the importance of creating a will to ensure smooth succession of assets. Joining me to do that today is Neha Pathak, Head of Trust and Estate Planning at Motilal Oswal Private Wealth. Neha, thank you so much for coming in. Welcome back to the show.
Thank you.
Always a good thing to have you on. I remember it was an earlier show where we were generally talking about what women need to do, and we had you on as a teaser. And I remember saying that to viewers that we need a full-blown classroom on this. These are legal matters, can get quite tantalizing to say the least, I'm guessing.
Absolutely, it's tantalizing. You're so correct with that word.
So the idea is that, let's start with some broad thoughts. When we talk succession, at some point in life, it's about knowing what's my due. Will I get my share? Because I am due to get some inheritance. And then beyond a certain stage in life, it's about how I need to plan the transfer of my assets to the next gen or to, whoever might be the intended beneficiary. How should one overall look at the concept of transfer of this wealth?
So see, if let's understand this, that in India, there are many personal laws. So multiple religions are there. There are multiple personal laws that are there. If I have got assets and if I pass away, what is the law that's going to govern me? And if I die without having anything in place, so be it to say that if I don't have a will in place, I pass away as an intestate without anything in writing. Now, when I pass away without a will, my personal succession law will come in. For Hindus, it's going to be a Hindu Succession Act. If I'm a Muslim, then it's a Sharia law.
Sure.
If I'm a Parsi or a Christian, then probably the Indian Succession Act.
Okay.
So that is what is going to govern what happens to your assets if you pass away without anything in writing. So it becomes pertinent for all of us to actually make a will, so that we can mention things, how they should be done and what should be the procedure of doing that.
Sure. Right? So we'll obviously come to that, and that's the bread and butter of what we're trying to do today. But just to understand the law, like you said, if someone passes without a will, then it's called, passing away intestate, right? Yeah. So these succession laws between different religions, are they tremendously different? Or is the Indian succession law somewhat similar to, say, the Hindu succession law?
I would say Indian succession law and Hindu Succession Act are pretty much similar.
Okay.
It's a little different from the Muslim succession law, with Sharia Act rather. Right. The main thing is mostly it's the family member that is covered.
Right.
The near and dear ones who are covered in the law. It says that if a person passes away, how much share will go to his wife, how much share will go to his mother or to his children. That is written in pretty much most of the laws.
Sure.
So that is what a personal succession law is.
Got it. So for the sake of understanding, now viewers, remember, this is what we're trying to understand, that if you or if we pass away without a written, clear, stated will, then how do the succession laws come into play? So let's take the Hindu succession law as example. If I pass away, I've not made a will, who gets my money or my wealth or my property and my assets?
So depending, if I talk about a male Hindu, if a male Hindu passes away without a will, his share gets equally divided between his mother, his wife and his children in equal proportions.
Okay.
In case either one of them is not there, then the remaining people will get it in the equal proportion.
Okay.
If none of them are there, then their children, so if the man's grandchildren are there, they will get it.
Okay.
Or else if he has nobody, then there is something called a class 2 heirs that are defined under Hindu law. They will be getting the assets of the deceased.
Okay. Now, do these legal heirs, do they have to prove that they're legal heirs to get these assets? For instance, if this Hindu man passes away, will the children or the grandchildren, what do they have to do? Or is it simply passed on because it's built into the law?
No, it doesn't get passed on because it's built into the law, because there is going to be an equal proportion of everything. So generally, people have these common consensus amongst themselves that let's distribute assets, father's assets between us in this manner. However, there are certain places like maybe a bank locker or a property where you would require a legal document to state that I'm a legal heir of a such and such person. Now, these legal documents can be procured by a court. So one has to go to the court to get these assets transferred in their name.
Okay, all right. And what's also important to know, like you said, the succession laws, I think, were amended a couple of years back. You're saying it's equal proportions. So sons and daughters, technically as per the law, are entitled to an equal share of the assets.
As much as mother and wife.
As much as the mother and the wife. So mother, wife, the children, which might be son or daughter, everybody's entitled to an equal share of assets. Okay, now we come to the operative part. If this is already clearly defined in the law, then why is it so important that we make a will regardless?
So we'll continue with the same example. This man has passed away. His assets are going to 4 people. Now, he may not want that. His mother is quite old and he might be having some other siblings also. Probably his idea of earning the assets was giving it to his wife so that one can take care of his children and his mother, and his wife is capable of doing that. He didn't want that his assets are divided 4 ways equally between 4 people. So it becomes important for him to have that thought in place and have that writing in place that in case something happens to me, my assets go to my wife. And in case she is not there, then it goes to my children. Probably he doesn't want to give anything to his mother. So that and probably he wants somebody to take care of his mother. So think about it that way. Also, there is a possibility that one may want that a certain portion, like people say that I want to give back to the community. I want to give back to the community. Now, if this man's wish was that I want to give a certain portion to the community or to an institution, then that will not come true if he has not done anything in writing.
Oh, absolutely. So, I mean, that has to be a starting point. You have to state your intentions in the form of a will. Okay, so let's move to the next brass tacks questions then. How is the will created? I believe you need 2 witnesses. How complex or easy is the process? So how should one go about it?
So it's a fairly straightforward process. When you are looking at creating the will, there are certain basic guidelines you should follow. When I talk to my clients also, I tell them that when you are thinking of creating a will, put down who are the beneficiaries, who are your family members, or who are your beneficiaries. It may be a possibility your beneficiaries and your family member are different people.
Correct. You want to give it to some non-blood relative, your assets or
it can be a friend, it can be an institution, it can be anybody. Write down what your assets are. So my assets are real estate, investments. If I have got investments, where do I hold them? If I have real estate, what is my property? Where is it held? What's the complete address? Write down my bank account details, write down my insurance details, write down the details of the locker. Very important to write down the details of the locker. Where is it held? Write down where, if I have art or artifact, how have I procured them? Who has made it? So you should be as elaborate as possible when you are making the list of these assets. Even the shares that you hold of, if you are running a company, the shares of the company, you should mention the details of the shares. Right? Partnership firm or an LLP, put in the details of that. Post that, you put in front of every asset, you write who's going to get
the
this
beneficiary.
asset. Yes.
And
the next, and next to that, put in that, what if this beneficiary is not there, then who will it go to? Most likely the beneficiary is the spouse. Spouse will be pretty much the same age group as you are. If the spouse is not there, then who will you want this asset to go to? Very important aspect. Put in a residuary clause when you make a will, that if I have not mentioned something in this will, it will be covered by this residuary clause. Put in an executor. Executor is a person who takes the will to the court after the person who has made the will is not there anymore. This is an important person. Most likely it is again going to be your spouse, but preferable will be person younger to you, much younger to you, who can do all these things for you.
Usually the executor of the will is a family member. Can it be a non-family member
Yes,
as well?
it can be a family or a non-family member.
Okay.
Absolutely no issue.
And the executor can be one of the beneficiaries of the will as well?
Absolutely.
Okay.
Thereafter, you should have your PAN card, Aadhaar card mentioned in the will so that one can figure out where your investments are if they are linked to the PAN or Aadhaar. And always mention that in case the executor is not there anymore, then who's the next in line executor who will be taking care of these things. Now, we have made the will, we sign the will, the person who's making the will should sign it. The two most important people again are the ones you just said, the witnesses. So 2 or more witnesses can sign the will. That is what validates the will.
Okay.
After that, you can look at registration or you can just keep the will at your house in a safe place.
The witnesses.
Yes.
Do they have to be non-related, related, family members,
Ideally,
non-family
they should
members?
not be the beneficiaries in the will.
Yeah.
They can be relatives or non-relatives, doesn't make any difference.
Okay.
But they should not be beneficiaries of the will.
Okay, there should be independent witnesses.
Yes.
Got that point. So this is pretty much how it can be drafted. There's also a lot of talk of adding at times maybe a medical certificate proving that the person who's making the will is of sound mind.
Yeah.
Why is that important and how does one prove that?
So one goes to the medical practitioner and he gives a certificate that a person is of sound mind and is physically able to go ahead and register the will or make a will.
Okay.
If you are of unsound mind, then you surely can't draft any document. So it's important that one gets this kind of document from the doctor.
Okay, fair enough. You brought up the point of registration of a will. And I know that I think it's not mandatory to register every will, but why is it then advisable to do so? And when you say register a will, is it registered in a court? What's the process like? And what's the upside of doing this?
Okay. So registration under law is not compulsory.
Okay.
Why do we register the will? The first and most important point is that it gives me satisfaction that I have registered it with some government authority. Now, registration is done either at the sub-registrar's office or there can be a lower court in different jurisdictions. It's a different place. It can be a lower court that is registering the will for you. It creates a copy with the government.
Okay.
So if the person who has made the will is not there anymore, but he has informed his family members, I have made the will and I have registered it, the beneficiaries can go to the registrar's office and can get the will, copy of the will.
Okay.
It provides a sense of security that I have done something right and it is there in the, and people are aware that I have done something right. Also, when you go to the registrar's office to register the will, they actually ask you these questions that do you know the contents of the will, are you aware what is written over here, show your identification, and then they register the copy.
Okay. So, but a non-registered will is also legally binding.
Absolutely. Absolutely binding. So say for example, I made a will and I registered it.
Yeah.
But 2 years down the line, my asset base changes. Then maybe I might want to change my will. And I will change my will. So in that case, the will that I have made subsequently becomes the recent will.
Correct.
And that's going to be my will and not the registered will.
Okay. All right. Got that. So those are the nuts and bolts of making a will, which maybe is the easier part. Yeah. The harder questions are when to make, how to discuss it with your family, how to ensure that, there's, as less acrimony as possible, what to do about existing nominations, all of those technical questions we discuss with Neha after the break.
Let's talk money.
Welcome back. You're with us on Let's Talk Money, and this week we're discussing how creating a good, solid, foolproof will is probably the cornerstone of any plan when it comes to transfer of wealth, assets, or succession planning. And of course, I'm in conversation with Neha Pathak. Neha, before we continue, question cropped up in my mind in the break. We're talking about the interstate laws, which define how wealth will be transferred if there is no will. And they say, for instance, it will be shared equally between the deceased wife, spouse, and children. Where do nominations feature in all this? Because for all our assets, mutual funds, fixed deposits, everywhere, there's always a nominee. So how does that nominee tie in with the interstate laws and, of course, the will?
So if I talk about nominee, a nominee is a legal representative of the person who was the owner. He's the person who's supposed to hold on the assets as a custodian and thereafter transfer it to the legal heirs. A lot of times it so happens that the nominee and the legal heir is the same person, or there might be more legal heirs. So if I have nominated my husband as a nominee, but I have got kids, then in that case, my legal heirs are my husband as well as my kids.
Right.
However, nominee is only him. So he is supposed to hold on to the assets and distribute it amongst himself and the children.
So nominee does not, that's really important. Nomination does not mean that you get the asset.
Yes, it does not mean that. It means you get the asset to hold it as a custodian.
As a custodian. It is not for you to use and for you to, throw away the wealth or enjoy its benefits. So all you nominees out there, please realize that you're only the custodian of that asset. You cannot hold on to that asset as your own or use it as your own. Very, very important point there. Which gets us back to then, therefore understanding that the will is, making a will is the way to go. Just explain to us this concept of probate. And we keep hearing that despite a will, there are disputes in the family. The will is getting challenged, so on and so forth. Yeah. How can one try and minimize all of this?
So will is a challengeable document that we have seen.
Yeah.
Now, what happens is that when one makes a will, there can be an concept of fraud or coercion that may have played. And that is why, and some of the beneficiaries in the will might feel that I am getting less as compared to the other one, or I should have gotten that particular asset and not the other person. And which is why a person might contest the will. Now, when does this come? So when does a will come to light? I made the will, I have kept it in a safe storage. However, my executor will bring it out after me, after I'm not there. He would have to take the will to the court and get an order from the court, which is also known as probate, that this will is right, the contents are perfect, and the assets should be distributed between the beneficiaries that are mentioned in the will.
So this is really important. The will cannot be implemented, quote unquote, till there is a probate or this order from the court. Is that right?
Exactly. Not for all the assets, probably. Some of the assets can be distributed between the beneficiaries if they are of the like mind or they think that it should be distributed.
When it's amicable, yeah.
But when it comes to real estate specifically, the asset would be distributed only after probate, and it's safer to do so.
Okay. Okay. All right. So therefore, you go to the court.
You get an order.
Get an order saying that the will is, has been sort of approved by the court, so to speak.
Yeah.
And then it can be implemented and the assets can be distributed. Got that. So that clears up a lot of the technicalities. Now, just some, life situations as we're coming to the final leg of this conversation, Neha. And life can be very uncertain, right? There could be cases where you are creating a will, whether it's for your children or, family members. There could be separations, there could be divorces. So what do you do in such a case? Because in a happy situation, you wouldn't mind the asset being shared by your son or daughter and their spouse. But in a different situation, you might want that asset to be secured only with your own child.
Right. Now, two aspects of divorce. Either the parents are getting a divorce or the child is getting a divorce or a separation, right? These are the two aspects.
Yeah.
Either which ways, I think the best way to move forward would be to ensure that the child is well protected, is well taken care of. So there should be enough insurance to cover his medicals. For his education, there should be a fund. There should be fund for his education, medical and maintenance. Maybe sometimes people do create a certain portion for his marriage. So all these things are very important, and they cannot just be done by a will. Maybe one can look at creating a private trust where these assets can be housed and they can be secured against anybody getting a separation. And they are used specifically for the child or children and their well-being. So,
okay, that's how it goes. From a broader legal sense, whatever are the assets that I own as a male or a female, going back to the interstate laws, they typically go to, like you said, spouse, mother and children. Do the spouses of my children also have any direct rights on the family assets, my assets?
So spouse of the family, of course, yes, they
Yes.
have a direct right if my child is not there anymore.
Uh-huh.
And-
Oh, if the child is not there, only
Yes,
then in that
yes.
case.
In that case, he might get a right over there.
Mm-hmm.
So one needs to be careful about what is written in the will. So when I said that the 1st leg of beneficiary, you should identify that who's going to get the asset. The second leg also should be identified, that what if my spouse is not there? What if my child is not there?
Yeah.
Then who will the asset go to?
Okay, all right, fair enough, got that point. Last but not the least, the assets, once they're transferred, are they still subject to any kind of scrutiny? It could be, the authorities, it could be the income tax department, ED, anyone. Are inherited assets still subject to government scrutiny?
So if the government thinks that you have received the funds and these funds were tainted funds, yes, there can be a scrutiny on that.
Okay.
So sovereign is always
Above
everybody.
everything.
Yeah. So yes, that can come.
And
However,
taxes?
Taxes in India, we do not have inheritance tax or estate duty. So one who's inheriting doesn't have to pay tax on the inheritance.
Yeah, so far so good, fingers
So
crossed.
fingers crossed for that one. However, there is, if there is any income that is earned on the estate before it was distributed, that tax has to be paid. So income tax or capital gains has to be paid. After it is distributed, it is upon the inheritor, whether he's selling it, he's keeping it, he's earning rentals or dividends. Then there might be income tax or capital gains,
whatever.
on
I
that.
mean, then it's your asset and you have to pay
Absolutely.
taxes as per the applicable laws. Got that. Now, finally, to sum it all up, I mean, what's your final advice? I'm sure you've seen enough families, enough situations out there. I mean, usually is it simple and clean with a will? What can be done to ensure? And it's also taboo subject. I also come across people who don't want to discuss the division of assets, right? It's a difficult topic to broach with the family.
Yeah.
And usually it's left till the very last minute, or it's not openly, even no one knows if there's a will or not.
Yeah, I
How can
totally
this
agree.
best be handled?
So I think the best way and the most straightforward way is be practical about this approach. People tend to get very emotional about it, but till the time you are practical about it, you can go ahead and finish this process. And it's a very fairly straightforward process. Do it, finish it, keep it aside. People think that when I am about 80 years old, that's when I'll make the will. It's not going to happen. You don't know when you might die. So might as well create a will and put it aside. So that's the simplest and the most straightforward way, whatever your age group is. If you have assets, might as well create a will and keep it aside.
Okay, all right, do it now.
Yes.
And then sleep easy, sleep in
Absolutely.
peace, so to speak. All right. Neha, thank you very much. This was a
Thank you,
good,
Surbhi.
quick crash course on the basics at least, enough to get us started, to take appropriate advice and to ensure that succession planning is far more structured and clearly done. Thank you for joining us on this.
Thank you very much, Surbhi.
All right, folks, hope you found this conversation fruitful, useful. I certainly did. Keep sending us your feedback, comments, queries, and as usual, we'll see you again next week with another theme.
Let's talk money.